Aloha. Friends of the East West Center welcome its members, East West Center community, and those of you joining us for the first time. Bankruptcy can be bewildering. Bankruptcy with Chinese characteristics, even more so. You'll need a good lawyer to explain it all to you. To do just that, China Seminar is privileged today to have as our speaker, Professor Charles Booth. Professor Booth is a leading expert on the subject of Chinese bankruptcy law. He's done extensive research on insolvency and commercial law with a focus on Hong Kong and China, and he's written and lectured widely on the subject. Professor Booth is the Michael J. Marks Distinguished Professor in Business Law and Director of the Institute of Asian Pacific Business Law at the University of Hawaii's Richardson School of Law. Following his talk, East West Center Adjunct Senior Fellow Rick Hornick will moderate a discussion. Welcome, Charlie, and the floor is now yours.
Thank you so much, and thank you so much for the introduction and for the invitation to speak to everyone today about Chinese bankruptcy law. Unlike most people in the audience, I grew up with bankruptcy in that my father and grandfather were both bankruptcy lawyers. So around the dinner table, we talked about bankruptcy law. It was always something I thought I wanted to do. When I practiced on Wall Street at Cleary Gottlieb, I had some experience with a cross-border case involving China and came to Hawaii in '86. And I was very, very lucky that I was able to get fellowships to go to Asia in the summer of '87 and '88 to take a look at Chinese bankruptcy law, Hong Kong bankruptcy law, Japanese bankruptcy law, and Singaporean bankruptcy law. So I've been looking at this topic for a very lengthy period of time. So what I'd like to do today is introduce you to, I've come up with about 5 periods. They're artificial, but I think they're helpful for purposes of discussion. I'll take you through the trends and developments in those periods, and then we will have time for questions. So the first period is starting in the 1980s up through 1994. The second period will be from 1994 to 2007. The third one for the decade leading up to 2017, and the fourth period leading from then up to the present. And then I will try to make some predictions for the future. So as it so happened, the first time I arrived in China in 1988 happened to be the year that their new bankruptcy law, their first bankruptcy law, came into operation. It had been enacted in 1986, came into operation in '88. And I remember meeting with a senior professor at one of the Chinese universities discussing this law. And the way he put it was, the law was the medicine, but there was not yet any disease. So that was back in 1988. And sure enough, 1989, you have 90 cases. The next year, 32 cases. The cases lumber along in the low hundreds, hits 1,000 in 1994, and then hits a peak in 2001 of about 100 cases under 9,000. So keep that number in mind because it's important when we take a look at those numbers. So when you take a look at China at that time, as they are developing their economy and beginning to change their market system, it is understandable that many of the old state-owned enterprises were going to have some financial difficulties. For those of you who are not familiar with the term state-owned enterprise, not just in China, but in many, many countries, even to this day, these are business operations that are tied to social benefits. So in China, you might have a SOE that might have 100,000 workers, even 1 million workers. In addition to trying to operate a business, you're providing often flats, medical benefits, maybe even issuing passports. So it's like a mini community tied to the business operations. Now, the reason why that is significant is if that state-owned enterprise enters into a period where they cannot repay their debts, that's going to put these other benefits in jeopardy. So therefore, in 1986, when China enacted their first bankruptcy law, it was for state-owned enterprises, only for state-owned enterprises. It was a short law with 43 articles setting out what you needed in the rudimentary nature for an insolvency system. Shortly thereafter, there are some amendments made to the civil procedure law, and those are dealing with non-state-owned enterprises, legal enterprises, and that's 8 articles. So those are 9 SOE legal enterprise persons. So of course, if you have laws with only 43 articles, 9 articles, it's not going to be comprehensive. So over the years, the People's Supreme Court has been issuing judicial interpretations that fill in the gaps in the law. So as every year goes by, the law is getting more and more complete. But even with the development of that law, there was a sense that the law was insufficient at that time to address the problems in China. And the government starts issuing policy decrees for certain SOEs, often in certain cities. And then on top of that, you also have local rules and regulations in certain cities in China. Most significantly, Shenzhen, closest to Hong Kong, they do not have the same debt overhang that you had in other cities in China, so they have local rules and regulations. So they were up and running with this law, but within about 5 years, they realized that it was insufficient to deal with the situation that they were confronting. So in 1994, they start drafting a new bankruptcy law. Now that period is very, very important because if the process had gone smoothly, within 5 years, they would have had a new law on the books. But a few things happened. The first one was the magnitude of the problems that China was confronting demonstrated to them that they could not just wait for a bankruptcy law to come in. They had to act immediately and they had to do something. And it is here that we see the strength of the Chinese approach. It's flexible, practical, pragmatic, and multifaceted. They tried certain procedures in certain cities, debt for equity swaps. They tried liquidating inter-SOE debt amongst the SOEs and their banks. They tried mergers and acquisitions, sometimes with bankruptcy, sometimes without. They tried a whole array of mechanisms to try to address the problem. Now, in so doing, they realized with a lot of these SOEs that they had a big problem on their hand with how to treat the workers. As I mentioned, if you have 100,000 workers or 1 million workers, if you just strictly liquidated, then you have the problem of how are you going to take care of all of these individuals. And it really was this issue of what to do with the workers that slowed down the drafting of the law. At times completely, at times they stopped the drafting, and they're trying to work out the priority amongst the workers and the financial institutions. But then something else happened, the Asian financial crisis. That hits in 97, 98. Now at that time, China was very, very lucky compared to its neighbors. But as they looked around its borders, they saw the problems that were ensuing everywhere. Now here, I'd just like to make a few points about the nature of insolvency law in Asia at that time, because although we're talking about China, we have to look at China in the Asian context. And at that time, I think it's fair to say that the laws in every jurisdiction, perhaps with the exception of Singapore, were underdeveloped and not up to the task of dealing with the Asian financial crisis. For the most part, they were liquidation-based procedures, which means that you would gather together all the assets of the insolvent company, sell them off, and then distribute the proceeds to creditors in their order of priority. At that time, there was very, very little restructuring in Asia. And those of you who are familiar with US Chapter 11, that is the norm. Rather than liquidating in the States, you try to restructure both the debt and the operations, keep the company operating. And the idea is that that rehabilitated company will be able to generate a higher cash stream, cash flow that will pay creditors more than they would get in a liquidation. So when the Asian financial crisis hit, there were problems throughout many of China's neighbors. And most significantly, the banks and many of its neighbors were getting decimated. Now, if you have a banking failure, a systemic banking failure in your country, you have to address that first before you can talk about addressing problems in the corporate sector. And China saw what was going on in Malaysia and Japan and Indonesia. The banks were hemorrhaging cash, they had to be saved. And what many of those countries did is they enacted legislation or issued decrees to set up a national asset management company that would take care of the bad debts that the banks had. We called a good debt a good bank, bad bank system. They took over these bad debts, and the idea then is to strengthen the banking system in those countries. Now, why do I mention this? Because China saw what was happening, and during that period, they did something similar, but on a different and much larger scale. And this is where I talk about the practicality of the Chinese approach. Rather than setting up one asset management company, they set up one for each of the four major banks. And the idea was these asset management companies would be in existence for just 10 years. But as it turned out, they actually became part of the financial framework in China. And the result was years later, if we go beyond the year 2000, those banks that had been saved by the asset management companies listed on the Hong Kong Stock Exchange, and at the time were the largest IPOs in Hong Kong's history and perhaps worldwide. Huge, huge success. Goldman Sachs, Bank of America invested in these companies. And one of the ironies was that when we had our own crisis years later, that Bank of America wanted to increase its investment in China at that time in their bank because they were doing so well. So that would be an example of, at that time, while they are drafting this new bankruptcy law, meanwhile, they came up with a completely separate approach to save their banking system, which shows the ability to work on different tracks at the same time. So the result was, with all these mechanisms that China was trying out domestically, and with debate over what to do with the workers, it took a while for this law to come into operation. And although most of the provisions were set back by 2001, 2002, they still were not able to enact the law at that time. And one of the issues, and when we look back at that time, it seems ironic, was what to do with some of the largest, most important, oldest SOEs. Should they be subject to the new law, or should they be handled outside the law? That was a big issue of debate. And at the time, there was a compromise that was entered into. But when the new law was enacted in 2007, there was a sense that the procedures between SOEs and non-SOEs was going to be harmonized. But as we'll see from that time, that really is not what has happened. And we still have a two-track system. Now, one of the things to keep in mind about corporate insolvency law reform, and this is true in Asia generally, and it might sound unusual when you hear it for the first time, is that when countries enact new corporate insolvency laws, in most countries, the cases actually go down initially rather than up. Now, you might ask, why is that the case? These are better laws, they're drafted more clearly, and why should the cases be going down rather than up? Well, the reason is that parties like predictability. They like to achieve as much certainty as possible, and they do not want to be the guinea pigs trying out these new laws. So the one exception to that development at that time in Asia was arguably Japan, which saw their cases from the get-go head in the north direction and increase. But in China, we see that once the law is enacted, there's a slight increase in 2008. The year before, there were 3,200 cases, went up about 800. You can see well below the number I mentioned to you a little while ago from 2001 of 8,900 cases. But then they went down. They go down to 2,400, 1,900, 1,300. As the new law is coming into operation, as people are getting experience with it, the cases actually start heading down. So for many years, when I would give talks on the Chinese bankruptcy law, I had many slides on trying to explain why this was the case. Why were the cases going down? And given our time constraints here, there's no need to go into that, because eventually the tide turned. And in 2017, the number of cases hit 9,700 and finally exceeded the number from 2001. And then since then have been going up dramatically. Now here, the data is an issue. It is hard to get official state counts of cases, and even most of the data that I use and that most commentators use is actually provided by non-government entities. And right now, the estimates are that in 2022, that there were as many as 30,000 cases. And arguably in 2023, 2024, those cases are going even higher. Now, we can look at what the reason is for that increase in cases, and there are many. One of them is that, first of all, the new law is much, much better than the old law. It was more comprehensive, It addressed more issues. At that time, China, like many other jurisdictions, wanted to incorporate aspects of Chapter 11. Chapter 11 is always considered the benchmark by which countries judge their restructuring systems. Although, and this is a topic for a different day, my own view is that Chapter 11 does not travel very well because Chapter 11 works in the States for reasons unique to the US. Judges with decades of commercial experience, very strong creditors committees, you have entities that provide debtor in possession financing, and many countries such as China did not have the benefits of those aspects when they enacted their new law. So that is why it first took a while for the law to develop to work out those issues, but the Chinese did so, and it's really in 2016-17 that there's two main changes occur that lead to this dramatic increase in cases. The first one is that the Chinese government realized that they had to improve the professionalism and expertise of the courts. A lot of the judges that were hearing the cases historically had not had any experience in this area, and every case that came to them was a new matter with which they had to deal. So what they did in 2016-17 is they set up in certain parts of China specialized courts dealing with liquidation and bankruptcy issues. They wanted to hire very good graduates. They wanted those graduates to get advanced degrees. When I've been in Hong Kong, I've met with some of those judges who were studying in Hong Kong, and I was lucky enough last year on a World Bank project to be involved in the first training for the Beijing bankruptcy judges, actually for the first training of any judges in China. And they're an impressive lot, well-trained, well-educated. But the difficulty in China, as with many civil law jurisdictions, is that individuals become judges out of law school. It's unlike the US, unlike the UK, where you become a judge at the end of your career after you've had all of this business expertise. So although the expertise is increasing, it makes it very difficult to handle very technical, very difficult cases. A lot of the cases coming through can be handled, and that's one reason as these judges got better and more experienced, we see this increase in the caseloads, and they can deal with it. Now, the second factor that leads to this increase in cases and the acceptance of cases is that China created a very impressive online filing system and bankruptcy system. They have different platforms. They have platforms for filing petitions, platforms that the judges work on called the working platform, bankruptcy administrators platform. And then once things go online, that's also a way to ensure that cases are progressing accordingly. When cases were not online, it could often take time to see what the problems were, what was slowing things down. But once that happened, we see things moving through much more quickly. Now, I should say here, and this can lead to some inconsistent results, is that one of the ways that Chinese judges are assessed each year is the ability to which they complete their cases. Now, that assessment mechanism actually is contrary to insolvency cases, because it might be easier for a judge just to say, oh, we'll liquidate, we'll let the secured creditors enforce their interest, we'll everyone just grab as many assets as they can, and I can close 50 cases very efficiently. Where if you have an insolvency case, that could take time. That could be a problem. And that is one of the issues that is being dealt with now. But that takes us through 2017. We see that increase. And now, in the last part leading up to the current situation we're in, I'd like to talk about over the last 4 or 5 years and a few words about the Chinese system that we see today. In essence, what has developed is that although we have this dramatic increase in cases, it's not the large cases. It's not the Evergrandes of this world. Now, Evergrande is the one that's been in the news the most because of the size of the debt. It's estimated to be as much as $340 billion. And then just 2 weeks ago, the Chinese government announced that there was an overstatement of earnings of 75 billion US. These are all US dollars, $75 billion on top of the 340 billion. Now, with an entity that size, the bankruptcy system they have is not really well equipped to handling a matter of that magnitude. Now, when you add together the other large China property companies, you're over $1 trillion US in debt that has not been paid. And just to give you some magnitude of this, and I've been trying to ascertain the number of empty units of housing in China. It's very hard to do. but the numbers are just off the charts. You know, there's estimates that there perhaps could be as many empty flats in China for everyone in China to live in. And if not that, maybe then some publications say for every American to live in at that number, the whole population of France, everyone's trying to come up with a number to show you the magnitude of the problem. So what you have right now is a situation where there's been a dramatic overbuilding in the area of housing for Chinese citizens. What is different about China compared to the US, for example, is that generally when you buy a flat in China, you're supposed to prepay. So you have individuals, millions of individuals who have put down their money for these flats, and then the flats hadn't been completed, hadn't been finished. So that can lead to problems of social unrest. So back in the 1980s, the social unrest that the Chinese government was worried about had to do with workers and workers' rights. Now it's very different. You have middle-class individuals who have put down money for flats. They haven't been delivered. Now, what we have to keep in mind here is that the one-child policy helped create impressive family wealth in China without having to worry about dividing up assets amongst one's siblings. Only children inherited property, and you had a lot of extra cash for many millions of Chinese citizens. With fewer investment opportunities in China than you have in the States, property was an area that people put their money in. And I taught in Hong Kong for 17 years, and I saw that from the get-go. There was a belief that you put your money in property, property can only go up. Well, it only goes up until it comes down. And right now we've got a big problem with the mismatch between supply and the market. And that's what the Chinese government is trying to work through at present. And the result is that when we take a look at Evergrande, this is a good example, they actually defaulted on their debt back in 2021. But there's yet to be a bankruptcy petition filed onshore in mainland China. And here's the last point I will make before we start going into other issues, which we can save for later. And that is what is now very complex about the Chinese corporate model is that most Chinese companies have developed very complicated offshore structures. What do I mean by that? They'll incorporate a holding company in the BVI, in Caymans. It's over there in the Caribbean where they're borrowing money, often in the hundreds of millions of dollars or more. That money then comes back into Asia. So what you have in Evergrande is a good example. They have a total of about 340 billion in debt. The estimates are maybe 20 billion of that is offshore, 320 billion is onshore. And then what happens is that when a company such as Evergrande misses one of their bond payments, at that point, the international bondholders are basically upset that they're not getting their debts repaid. They're looking for solutions. And that's when you see this flurry of activity offshore. You see offshore restructuring attempts in the Caymans and BVI in Hong Kong, and then they're often trying to come to the US to get recognition under Chapter 15 and try to work out some solution for the debt. But there's a mismatch here because all that negotiation is offshore, and that does not give them generally a right onshore. And in Evergrande, for example, there's a sense that that 20 billion is subordinated to interests in China, and right now is not worth much at all. I think it's trading for a few cents on the dollar, maybe 5 or 6 cents, where back in 2021, a lot of the individuals who bought in for 6 or 7 times that. So you have all of that happening offshore. And then just recently, over the last month, creditors came to Hong Kong and they asked for the judge to issue a winding up petition or winding up relief in Hong Kong, and the judge did so. So Evergrande now is subject to a winding up order in Hong Kong, which now gives the liquidators in Hong Kong the ability to go after the assets in Hong Kong. Now, recently, there was an agreement entered into between the mainland and Hong Kong to deal with these cross-border insolvency cases. And initially, I thought that for sure, the Hong Kong liquidators would go to China to seek recognition of that order. And I thought that might cause a problem for China because they clearly had not wanted to wind up Evergrande because for the last 2 years, they have not done so. But I had been in Hong Kong a few weeks ago, and after talking to a lot of individuals, I've actually rethought my thesis. And I'm not so sure that there's a need to seek recognition in China. Now, why is that? Why is that given what I just said? Well, the reason is that China has developed another mechanism for dealing with these large property companies. They've put great pressure on them to complete the construction of the flats. And by doing so, the millions of individuals who have bought those flats will have their flats delivered. And then a huge problem disappears. Secondly, and this is more recent, they have put pressure on the property companies to also start paying contractors and suppliers, because you want to unclog that part of the Chinese supply chain. The property market's a huge percentage of the Chinese GDP, and they want to unlock that. So what does that basically mean? Well, that means that the domestic onshore bondholders are now also being subordinated, that they now are going to have to wait because you have so little money to go around. Because in addition to the 340 billion in debt that was already acknowledged, now with the addition of the extra 75 billion in fictitious earnings, I think individuals realize that that's not going to get paid anytime soon. And there's a hope then that you can reflate the Chinese property market in years to come, and they will be able to hopefully get something at that point. Well, I went on for about 25 minutes. I will stop it there for now. You can ask some questions, and then there's a few other points I'd like to raise it as we come back to it.
Well, thanks very much, Charlie. That was terrific. Yes, please. We take the questions via chat so please come forward with them. In the meantime, let's start with these contractors. Because that's one of the things that I think has been very much undercovered. As you say, the real estate industry is an enormous part of the Chinese economy, and that means agents. It means service providers. So where's the money going to come from to pay them and finish off these apartments?
Good question. Well, first of all, in many of these property developments, the flat that the company delivers is very different than a flat that we would expect to be delivered here in Hawaii.
Mm-hmm.
And that the completed state often does not include the flooring, sometimes
right.
not even the drywalling. So you have the shell, and then these other aspects also have to get done. Right. So the problem is that unless you get the contractors and the suppliers involved and get them paid so they can do things, the flats cannot even be moved into. And that's a huge problem that they have. So then the question is, where does the money come from? Well, it's got to come from somewhere. So it can come from a number of places. There was a period where many of these property companies, not just property companies, other companies as well, had expanded their operations overseas, big investments, trophy properties. So one thing that many of these companies have done is they've sold off those trophies, although at this point they're maybe not as trophy-like with the downturn in commercial markets elsewhere, and they brought that money back into the mainland to basically use to pay for some of these things. Secondly, there are funds that historically would have been set aside for your bondholders. That money has arguably also been depleted. Thirdly, and the Chinese government has changed their policies over the years, but now with the big companies, it's easier for them to get some loans, and those loans then can also be used to pay back, to finish the completion of some of these projects. So it depends on the overall balance sheet of the company to the extent to which this is going to be sufficient or whether it's not going to work. And that's what they're working out with all of these property companies, to what extent they can complete. And it also makes a difference where the property is located, because if the property is located in Beijing or Shanghai, once it's completed, then someone very easily can then just rent it out as investment property. If it's in a tertiary city, well, that of course can be much harder. And if you're in a big development that hasn't been completed, then even if you get delivery of your flat, that could be still difficult.
I mean, you've talked about Evergrande and its overhang, but as you just mentioned, there are probably half a dozen other giant real estate developers who, much bigger than anything that we even can comprehend here. So you were trying to figure out what the total number of empty vacant apartments is. How about what's the total number of debt overhang in the real estate industry? Take the 400 billion of I mean, is it a trillion? Is it a, a trillion
Oh,
and
it's
a
well
half?
over a trillion. It's well over a trillion. Trillions easily hit. Once you get up there, I think you probably hit 2 trillion when you add everything together, especially when you work in the secondary amounts. I don't know after beyond that, but also keep in mind, and it's true with real estate market elsewhere. There's oftentimes when you have real estate insolvencies, the owners of the property want to buy time, because when you buy time, the assets can reflate. That certainly is what happened in Hong Kong. That's what happened throughout Asia. So to a certain extent, that if you can just hang in there and basically at least keep an operation, then you'll be able to be in business when things eventually improve. And that's sort of the hope. The difficulty, of course, now is just working out the demographics for China in terms of the number of units that they have built.
But I mean, is it a serious hope, or is it just kicking the can down the road and, Mr. Macabre or something will come up? Because, one of the big differences between I covered the savings and loan crisis back in the late 80s, and you had vulture funds, and you could, these things were marked to market. But, Japan never did that, which, was why they went through 20 or 30, one of the reasons they've had 20 or 30 years of stagnation. There's no hope that China would permit something like that, is there? Although you said they're very flexible and pragmatic.
Yeah, no. Right now, if you take a look at Sunak's another large property company, they actually did complete a restructuring in China, and there was a sense there, that the owner put some money in. They were in cities that was more beneficial. There was a bit more transparency with their creditors, and they were able to buy time. To a certain extent, yes, you are kicking the can down the road. There's no doubt, and there's also no doubt in Asia generally compared to the States. And this has been one problem when we talk about restructurings in Asia. It's been more on the balance sheet side, much more than the operation side. When we take a look at U.S. Chapter 11s, it's very, very much on the operation side. So that's a problem in Asia generally. But it's certainly possible if you take a look at China and you project out, let's say 5, 10, 15, 20 years in certain parts of China, the problem will be to a lot smaller extent than now. And some of the other cities where the tertiary cities where, let's say, too much building had gone on, then there will have to be other approaches to work through. But at this point, there are steps being undertaken, and right now, I said the immediate desire is to finish off as many of these flats as possible.
So Zhuofang Wang is commenting that noting that a major part of the financing of real estate has come through local government, local governments through local government financing programs, which are in themselves a mess. Is there any possibility that local governments can't go bankrupt, can they? Although it's my understanding, and maybe Mr. Wong or Ms. Wong would like to comment on this, that local government financing vehicles are actually not owned by the local governments themselves. There's something that's been set up with an implicit guarantee from the local government. Anyway.
Well, I think
so.
Well, I'm sorry. You want to?
So can they go bankrupt?
No, that's not going to happen, I think. But you just identified one factor that's very important and significant, and that is the relationship between local government and the judiciary and these systems, and there's very, very strong connections there. That is one reason why in these highly, I don't want to call them sensitive cases, large cases, the decision whether a case is going to be accepted is going to be a governmental decision. Many of the reasons that you're mentioning here, because if that entity goes under, the local government is also concerned about who's going to pay historically with the workers, who's going to take care of various things. So the phrase we often use is policy bankruptcy. Basically, you have to work all those issues out. So if you think of during the Great Recession that we had in the States, when Chrysler and GM went into bankruptcy, at that time, the US government was the lender of last resort. And basically, they backstopped the system. And what I've said for many years, when it's often asked in China, when they want to learn about Chapter 11, what should they look at? I said, well, you want to look at those cases. You want to look at the cases in which the government was involved. Now, in the US, when the government went in, because of our system, there's a sense they should get out as quickly as possible. But in China, that's not the case. And to be honest, in many, many countries in Asia, that's not the case. There's actually much more government involvement in the insolvency process in Asia countries, actually European countries, than we have in the States. And there are these policy aspects that are more overtly taken into account than we see in the States. And that is why it is more regional in terms of what they're doing. So in basically historically in parts of China with less debt overhang, they could be a bit more flexible in terms of what they were doing with their insolvency system.
Yeah. Beichun Huang has a question or a note. Thanks for the speech. I want to ask, what is the main reason for that decrease in cases that you mentioned? One, government restrictions on courts to accept the cases. Two, low willingness to use bankruptcy procedure. The interaction of 1, 2, and 3, 1 and 2. Other issues? You said you had, you
I would say all of them. Back in that period from when the law was enacted for the next decade, they were all the case. A lot of the judges were reluctant to accept these cases. And secondly, in larger cases, the local governments did not want the cases to be accepted until they had come up with a solution. But let me even, I was showing beforehand, I have a sophisticated chart that I put together here that I'll share with you that maybe helps a little bit. As you can, unlike others, I'm very, very low tech. So here's a chart. There's two, as you can see there's two circles. One of them is shaded all throughout. That's the US system. So generally when you have a company that can't pay its debts when they come due, always you want to reach agreement out of court if you can. It's cheaper, it's faster, it's more private, it's the best way to go. But in the States, generally, if that's unable to be achieved, then the company will file for Chapter 11, and then you have the process starting, you have data, you can see what's going on. So that's the US. If you take a look at China, and it's even more so in places like Cambodia and Vietnam and Laos, that's not the case. When companies are not paying their debts, the majority do not end up in bankruptcy. They're outside the bankruptcy proceedings. And for years, it's been said in China that for every one entity that goes under, perhaps it's 250 or 300 that basically just fade away or other mechanisms are taken. So when we have that new law coming into operation, they're sort of finding their way of what to do. And ideally, you're looking for cases where you can complete the case in a way that your objectives can be achieved. If you have a very, very large SOE with 100,000 workers, 200,000 workers, and the local government is not sure what they're going to do, then you have a difficulty. And that is why at the same time that you had those cases, they had these special decrees for what to do with workers. And one of the saving graces in some places is that the land use rights in many parts of China were worth a good amount of money. If you found in that insolvency or even outside insolvency, another investor who wanted to come in, the money that came in to buy those land use rights could then be used for what they call the resettlement of workers, the retraining of workers, so they could find something else to do. Now, when they did that in some of those cases, they actually leapfrogged the workers over the secured creditors because they wanted to make sure that you had that done. So in some of these bankruptcy cases, you're sort of working things out. And it's not as if there's, and this is important to keep in mind, it's not like there's just one lever that's being pulled and the government saying what to do. Some of these cases are just so complicated, and you have involvement at the local level, the regional level, and you have different government entities getting involved throughout. And I think it's fair to say that in the process generally, there's much more interaction with the government for achieving a result than you would have in a place like the US. So in cases where that worked out, is more easily to be done. There's one other factor here. It's a technical bankruptcy issue, but it's a very important one that plays out in this case, is that historically in countries with socialist legal systems, in bankruptcy, they had committees that basically involved government officials and entities that basically had the same powers as a trustee or administrator would have in Western countries. And when the new law was enacted in China, the idea was, and this is the idea of the draftsman, was to move more towards that administrator model. But when we fast forward to today, that has not been achieved nationally. And there's a bit of a mix there. In some cases, the courts think it's still better to have this committee where you have all the various parties involved so they can be at the table. But however, in many of, I think, the smaller cases, let's say the more commercial cases, there the administrators are proving successful. So I think when you take a look at why the cases weren't being developed, that administrator system was not yet adequately at the level where things could get done. And then there's one last point. This is a very important one. It's a technical one, but actually makes a huge difference, is that bankruptcy law is very procedural. There's a huge amount of issues that have to be addressed. And because of that, it's ideally you do not want to enact a new law until all your subsidiary rules and regulations are in place, because so many questions arise, and especially in a civil law society, when you don't have answers to those questions, it leads to a logjam. And then that's when the People's Supreme Court starts issuing practice instructions. So for that first decade, it took a long time for all those pieces to get into place. But in many other Asian jurisdictions, the exact same thing. The law is enacted. It's over the next decade that those rules and regulations come into place. And once they're in place, once the judges get the expertise, once they get some comfort, once the administrators know what they're doing, I think that's one reason, even before the two changes I mentioned to you, that's why we start seeing those cases going up in 13, 14, and 15, and then we're moving in that direction.
Well, so that raises an interesting issue. So maybe we're over focused on Evergrande and the big cases, and we're missing the development of the bankruptcy law and procedures for the vast majority, if not in value, at least in numbers, of Chinese companies, private, let's say, privately held. So how would you assess that? And also, which regions do you think probably have the most well-developed systems? And thirdly, can the other regions then learn from or be forced to learn from the experiences of their colleagues?
All good questions. And that's actually the situation on the ground. I think that's true in the States as well. We end up spending most of our time talking about the largest companies, but actually in China would be another example of this. The greatest number of enterprises being started are very small enterprises, right. MSMEs, medium, small, micro, small, and medium-sized enterprises. And worldwide, that group has been, in many cases, ignored or not treated well because of the financial aspects and the cost of the procedures. And this, in your question, actually leads into something else that's different about China that I think has to be mentioned, because especially for the Americans listening today, it's a very different situation. And that is that China does not have a personal insolvency system. Individuals cannot go bankrupt. There's a trial underway in Shenzhen and a few other cities where you can do that. But for individuals, you do not have the mechanism for going under. So especially for small businesses, it makes it very, very, very difficult for them to function in that environment, because when things head south, they have difficulties dealing with it. And that's a huge, huge problem in China. And that's true, I think, in many countries in Asia as well. So instead, when you take a look at with what happens to it within the courts, you're looking at smaller entities, smaller companies, ideally with a business model that works. The SOEs are very, very different, because many of those SOEs, it was historical. You're trying to find a solution to a huge shift in means of production, especially in some IT companies, technology. There are a lot of successes. And over the years, when in my 17 years in Hong Kong, even the Hong Kong liquidators would often say, in many cases, they had successes in China, that it wasn't the case they couldn't get a fair hearing. It wasn't the case they couldn't get things done. So it really is, in that regard, it's a case-by-case basis, where if there is value there, if there is value that you can use to carry on the business, you will. If not, you can have an efficient liquidation system. But as your question, where's the development? And the government, I think, is basically with that. They're identifying those areas. Shanghai, Beijing, quite sophisticated. As I said, the professionals involved there are quite good. And I mentioned to you that judges in China sort of become judges from the get-go. One thing that's actually happened is that after some of these judges have gotten expertise, they've now been leaving the bench to go into private practice, because they have that expertise that can be used. And what's kind of interesting about it is that a lot of the men have done that. So right now, the majority of bankruptcy judges in Beijing are female. That basically there's the new orientation in terms of the gender makeup of the bench there. If we take a look at, I think, at the area of China that is leading in a lot of these areas, it's Shenzhen. Shenzhen did not have the debt overhang of the SOEs, and they've been in the vanguard of insolvency law reform for many years. And even right now with the personal insolvency system, you see that. And plus, you just have there's so much cross-border investment between Hong Kong and Shenzhen, especially that as that region grows and grows. I think there you'll see probably of any part of China the most efficient system. And then when we take a look at this makeup of the cases, and the problem right now, as I said, is very hard to get any data. I think you will see that in some parts of China, you'll have a higher percentage of cases going through what we think is the more traditional bankruptcy law doorway. And then in other parts of China, where those SOE issues have not been dealt with, then it will go through the more of the policy bankruptcy approach. Right. But to a certain extent, time will take its toll, because a lot of the individuals, and this is an important point to keep in mind, is that maybe you're a worker for an SOE and they stop paying you. On paper, you still have a valid debt, but over time, as that generation of workers passes away, the debts will pass away as well. So I think we look forward 20, 30 years, we're not going to be talking about this SOE, the old overhang. It's going to be more in terms of the areas in which money was invested in. The biggest one, of course, has been property.
Yeah, I mean, most of the SOEs have divested themselves of all the housing and all the other stuff. So it's more, So Philip Dieters asks, how much do traditional relationships affect insolvency outcomes, i.e., the behind the scenes, the Guanxi.
Huge.
And you mentioned, and also as our previous questioner brought up, with local governments, and you mentioned earlier as well, the local governments really call the tune on many of these things. Right?
Huge. And it's not just, and I think even when you talk to Chinese experts, they'll say the same thing, that when you take a look at the Chinese law, even in those formal bankruptcy cases proper, there's a lot more interaction with government officials than you would see in the U.S., for example. It's sort of built into the system. There's no doubt about that. Now, unlike other Americans, I'm not of the view that that's necessarily bad. In many countries, you want to go where the expertise is, and in many Asian countries, the expertise is on the administrative side. The difficulty, and I think this is one reason why some cases can proceed down normal channels and others, is that to what extent has the company been transparent in dealing with all of its creditors and all the related parties? When you have a case where they've done that, then that makes it easier to have a restructuring. And one of the problems, and it raises huge issues for the overall property market, is that the auditors for this company, PwC, how do you miss a $78 billion overstatement of revenue? So in some of these, what's going to happen now, what's already happening in the cases in Hong Kong, is that the auditors are getting sued. So when you have a case like Evergrande where they say there's fraud of that level, you're not going to recover the money. It's very, very difficult to recover money that's been lost through fraud in a bankruptcy case. And I often think that too many countries and too many people, they focus too much on insolvencies addressing the fraud issues, where that's more of a corporate governance issue up front. So what's been happening in many of these cases is you can collect a few $100 million US then from the auditors, perhaps to deal with some of these problems. But for dealing with the other issues, you have to look at the relationships amongst the parties. And then the other issue is, and China is unusual in this way, with this bifurcation between onshore proceedings and offshore proceedings in terms of where you are. And in each of these cases, you have to take a very close look at what those bond documents said as to where you are in the queue. And one of the questions that I've been asking parties over the years is, let's say that there was a hypothetical bondholder that held Evergrande bonds from the very beginning until the date of default. How would you have done? And the answer is, you would have done very, very well. Over the years, when Evergrande was current, huge payments were made. The problem, of course, if you're caught at the end when the market is sinking, then there's almost a complete loss. And I think at that point, the offshore creditors are in a very different situation, because they don't have the ability to sort of navigate through it. What China's working through on the onshore proceedings with these cases is, each municipality and the governments are trying to work through what can be done in these cases. But in the bread and butter cases, things can work just fine.
Xing Li, sort of summing up a lot of what you've said here. So the attitude of local, the attitude of local governments towards the bankruptcy of real estate enterprises is that bankruptcy cannot be used as a means to escape debt, especially when it affects the delivery of properties.
Yeah.
This is because government leaders need to take responsibility for the stability of the local area and cannot allow risky actions that may affect buyers who have already made payments. Let me just follow up real quick. Thank you so much. I want to ask whether the fractions of SOEs negatively affect the development of local systems. I'm not sure I understand that. So are the SOEs that are going bankrupt, does that also get played out in the sort of local environment?
Well,
SOE, it depends, right, on whether a national or a local SOE.
yeah, a lot of it depends on what benefits on paper have not been paid, what the magnitude is of what is happening. As every year goes by, I think some of those problems get better, in terms of that. But as I said, whenever we have the same is true in the States. Whenever you go through a crisis, you're always looking sort of in the rearview mirror to try to predict what would happen. And for decades in China, everyone was focusing on the issues with the workers. And then you fast forward 20 years, all of a sudden it's not the workers, it's all these buyers of real estate. The same thing happened in the US when our bubble burst in the home mortgage market. If 10 years before that, you had said that basically the collateralization of mortgages for houses could lead to the destruction of the US and perhaps the worldwide financial system, people would have said that you were crazy. And yet that's exactly what happened. So I think basically in different societies at different times, there's a misallocation of capital. And now when you take a look at those property companies, they're in the position that the biggest ones where they're too big to fail, and they need other mechanisms for them, the same way that we came up with them for GM and Chrysler. And unfortunately, Rick, I think you've frozen on my screen here.
Obvious problems with his Wi-Fi.
Well, while he's doing that, let me say a few words then where I think we're heading in a number of areas. I think one, because right now China never stands still, and right now as we speak, they're working on a draft of a new bankruptcy law that will address many of the issues that we've been discussing, and over the next few years, that we will see that law either being discussed or come into operation. Secondly, given the experiment in Shenzhen, there's also a draft of a national personal bankruptcy law that will also be considered in due time. And one distinction I want to make between personal bankruptcy and corporate insolvency is that, in contrast to corporate insolvency, where cases go down after a new law is enacted, a personal insolvency law is very, very different, because once individuals are convinced that this bankruptcy law can lead to a discharge of their pre-petition debt, you can have a dramatic increase in cases. So one of the examples that I give from my experience in Hong Kong is Hong Kong literally went from a few hundred cases a year to hitting a peak of about 25,000, and now decades later, a steady state of 6,000 to 10,000 cases a year. So if the mainland does enact some sort of a personal insolvency system, you will need a whole array of courts and individuals to deal with that. Another point is that China has to navigate this onshore-offshore dilemma that they find themselves in right now, where you basically have these two different systems that are competing. It is quite difficult. And if one takes a look at other countries, such as that's been mentioned with Japan, for example, there you don't have that onshore-offshore distinction. It's only what's happening in Japan. And then another factor, and this is increasingly a problem, is that in most countries in Asia, there's not a clear mechanism for bringing money into the system in the way of funding through what we call debtor in possession funding for the company, either into a period leading to a plan of restructuring, or even just while you're trying to get up to the time of efficient liquidation. And that is why, although if you put on the table the laws being enacted in many Asian jurisdictions, they'll all read pretty well, but in practice, some will be less effective than others if there's no mechanism for bringing this money into the system. And that actually has been one of the unique aspects of the U.S. bankruptcy system that has made it so effective, is this ability to bring money into the system. And that is what China is working on now. And in cases where there's been successful restructurings, they brought the money there. But we don't have a system as we have in the States, where when a petition is filed, that parties have an idea of that there's companies there who will do that type of funding and the like. Japan is a country that's been specifically focusing on that issue to try to increase the incentives for the private market to move into that area. And over the next decade or so, I would expect that those issues would be given a close look.
Thank you, Charlie. That was great. We've lost Rick to Wi-Fi problems in Florida, so he sends his regrets, but he sends his thanks as well for a great
My
talk.
pleasure.
China Seminar appreciates your participation, and we'll have you back.
Well, thank you very much. And I would just like to say that if anyone's any questions, please feel free to give them my email address. I'm happy to keep in touch with people, answer questions, and talk to them if
Will
they
do.
like
Will
to
do.
like more.